Good afternoon, everyone, and welcome to Edmonton Community Foundation's first online Wills Week. Thanks to an amazing group of volunteer lawyers, this year Wills Week brings you 10 presentations, each unique to inspire and guide you in the proper preparation of your estate plans. These plans include not only a will to protect your family, your business, and your assets, but 2 additional documents to help you during your lifetime if you are temporarily or permanently unable to be as independent as you would like to be. Understanding the hardships and additional costs that occur when these estate documents are not in place correctly will help you appreciate the value of getting professional help for you and your loved ones. This week, you will hear from lawyers about things done well and things gone wrong, how to plan for particular situations like blended families, a family member with a disability, and how tax planning can increase the amounts you choose to give. On Thursday evening, you can learn about how gifts that you include in your will to support your favorite organizations and causes can save taxes and allow you to create a meaningful legacy. Edmonton Community Foundation is pleased to provide Wills Week resources for Alberta-based will and estates information. It dovetails nicely with our usual role as a trusted resource for how organizations, large and small, enhance our lives in Edmonton, and further afield and how to create gifts that reveal your values in a way that fits for you. For this session, we are very fortunate to welcome Colleen Feehan from Feehan Law Office. Colleen practices wills and estates at Feehan Law Office in Edmonton, Alberta. After practicing on Bay Street as a litigator for many years and as an in-house counsel for a top 5 financial institution, Colleen's practice now focuses on wills, estate planning, power of attorney, estate administration, probate, guardianship, and trustee applications, and estate litigation. Colleen received her JD from Queen's University in 2009, her BA in English and History from the University of Alberta in 2006, and was called to the Ontario Bar in 2010 and the Alberta Bar in 2011. In her spare time, Colleen enjoys running, playing tennis, and spending time with her 2 sons. And just before I turn it over to Colleen, I'd like to let you know that if you have any questions during the presentation today, please type them into the Q&A box, and we will be pausing at 3 different times throughout the presentation to answer questions. So please type them in, and as we pause for those questions, we'll be sure to answer as many as possible. We'd like to let you know that we're also recording this presentation, and those recordings and each presentation that we're hosting this week, and each presentation will be available for viewing at some point in the next week or so. You can find those on our website at ecfoundation.org. So yes, I will turn it over to Colleen. Please take it away.
Thanks very much, Matt. Hello, everyone. Thank you very much for joining us today. You should be able to see my PowerPoint up here. Today we're going to talk about protecting your legacy through estate planning. And we'll get started. As Matt said, I'm a wills and estates practitioner in Edmonton. And I hope that you will ask questions today. I love asking questions. I love hearing new questions during these presentations because it sort of tickles queries that I may not have thought of before. So it keeps me sharp. So please feel free to ask any questions you have at those 3 checkpoints during my presentation today. And there'll be some trivia questions along the way as well. So maybe to keep everybody interested and invested. But yes, let's begin. So when you're looking at doing estate planning, it's important to plan ahead and sort of know what your goals should be and the things you might want to consider when you're looking at the estate plans. So today we're going to talk about planning for before the date of your death and after the date of death. And there are different sets of documents that govern what happens with your estate before and after death. So before you pass away, there are documents called a power of attorney and a personal health care directive, which dictate what should happen to you from a healthcare perspective and from a legal perspective if for some reason you were no longer able to make those decisions for yourself. And we'll go into that in more detail towards the end of the presentation today. But what we're going to talk about first is drafting your will and what the goals are for that, what you want to think of, what's appropriate to be governed inside and outside of a will, and those kinds of things. And today is primarily focused towards those planning estates, but I'm also going to talk a little bit about probate and things like that, which is usually more of a concern to your executor once their role becomes active, but we'll touch on it a little bit because I find people are often curious. So for our purposes today, the document that dictates what happens with your estate obviously is your will. So I'm sure most people out there have seen the show Modern Family. I was watching this one evening, and the patriarch character in this show is played by oh my goodness, is it Ed Harris? Oh, he's the fellow from what's the show about anyway. You can see the picture of him here. He plays the patriarch of this family, and he's got 2 adult children, a second wife, an adopted son, and a son from the second marriage. He also has a large affinity for his dog Stella, and he has a family-run business that he is handing down to one of his children. This guy is like the perfect client because he has so many issues to deal with. First of all, he's got children with different needs. He has minor children, he has adopted children. And so in his estate planning, he probably wants to think about how to keep those children equal in terms of entitlement. He also has a second wife who he needs to figure out how she is protected and retains value from his estate, but also in a way that doesn't create conflict with the children from the prior marriage. He has a family-run business, as I said, that he's handing to one child, but not the other 2 or 3, excuse me. And so how does he compensate those other 3 children for the value that he's providing to the child that is receiving that that family business? And I think like the silent issue in this one is that he has this dog Stella that you see sort of the progression of the show. There's always there's a bit of a conflict between the second wife and the dog. So I think he might be liable to create a trust and leave it all to the dog, which we can talk about more later. So anyway, this fellow is kind of the example of a very interesting client with second marriages, children from different relationships, adopted children, children with different needs. One is a minor, the other are older, and a family-run business, which can be very complicated, but is also easy to deal with. Oh, and I think he gives a down payment on a house to one of his children, but again, not the other ones. And so how do you figure that out? Yeah, on we go. So when you're doing your estate planning, it's not simply about just deciding who gets what. You're also going to sit down and look at your list of assets and determine whether or not particular assets actually need to flow through your estate, which means that they would be governed by your will. There are ways to carve off assets into different vehicles, which is for tax efficient purposes, creditor protection, and simply efficient transfer upon your death. And so it's important to look at these other asset vehicles when you're determining whether or not where you're going to let your assets be housed during your lifetime. So what passes under a will and what doesn't? Any assets that are held jointly with a spouse or other family member will not pass through your will because they're considered, on the date of your death, the person that you own that asset jointly with assumes all the interest in that asset. Not interest, but all the rights to that asset. So if you own your home jointly with your spouse, there's no need to transfer title to that property upon your death, because on your death, the ownership of that real estate would just simply now exist with the other person on title with you. Again, with a bank account, if you have a jointly held bank account, On the death of the first person, the bank account simply becomes the property of the remaining account holder. This can get very complicated as between adults, or excuse me, parents and adult children, and that's a bit of a bigger issue. So I often don't recommend that as a great solution. I think if parents are trying to give powers to bank accounts to adult children, that should be done under a power of attorney. But certainly as between spouses, having jointly held bank accounts and being held and being joint on title to real estate is a really efficient and important way to look at doing your estate plan, because if all of the assets are sort of taken care of this way, then on the death of the first spouse, there's actually no real need to do much estate administration on that death, and then things would just be wrapped up sort of on the death of the second spouse. So when you're looking at all of your estate planning, very important to make sure that assets that can be held jointly are done so in that way to avoid administrative issues later. We can also look at different vehicles wherein you're allowed to appoint a designated beneficiary. So this is life insurance, RRSPs, pensions, TFSAs. These vehicles, which are primarily meant to hold money, allow you to designate that upon your death, XYZ person will be entitled to this money. And this is very interesting because on your death, any assets in these vehicles does not flow through your estate is not subject to your will, but simply goes directly from your account to the person that you've designated onto that through the institution where that vehicle is held. And this is really efficient. So on your death, if, for example, you had a life insurance policy with particular beneficiaries designated on it, what would happen is your executor calls the institution holding your life insurance policy, provides them the appropriate documentation proving your death, and then that money is transferred often within days to the recipients of that policy. So this means they're not waiting for the funeral, they're not waiting for the will to be found, they're not waiting for probate, they're not waiting for lawyers to get involved, they're not waiting for executors to be figured out. They simply just get the money right then and there, and they get it tax-free. The same is with RRSPs. If there's a designated beneficiary on that RRSP or TFSA, again, the account is transferred often within days with no real big administrative issues. And with an RRSP, if it's transferred as between spouses, there are major tax benefits for that, as you don't on the death of the first spouse, you're not taxed on the income, or excuse me, you're not taxed on the RRSP, though you will be taxed retroactively after the death of the second spouse. So as between spouses, making sure you have your RRSPs designated to each other is a really efficient way of taking advantage of tax issues and also of making sure that those assets are transferred quite quickly and that it's not wrapped up in the estate. Again, pensions, those same kind of thing. And this is also sort of an interesting issue because, I mean, there's a little bit of case law that has thrown this into a little bit of conflict, but there's the possibility that if you're worried about creditors coming after your estate and some insolvency issues, you can actually protect some assets through these kinds of vehicles and carve them out for your beneficiaries away from creditors, because your creditors only have the right to come after your estate. To some extent, these vehicles protect assets outside of that because they directly go to your beneficiary after your date of death. Yeah, and also if there's no assets left in your estate, there's obviously no need to probate it. And the big things for probate are real estate and financial assets held with an institution, but we'll get to that a little bit later. So when, well, we're going to get to it now. So when would your executor need to obtain a grant of probate with relation to your estate? So first off, what is a grant of probate? A grant, I like to explain a grant of probate by saying it's sort of the rubber stamp that a court gives an executor, saying that they agree with the executor that they are the executor, that the will that they've put forward is the proper will, that the beneficiaries are the beneficiaries, that the assets are the assets. So this is a really, really important tool for executors to be able to go to the court and say, here's my plan, I think everything's on the up and up. This is what I'd like to do. And the court says, okay, we agree with you. And anybody who disagrees with you has a finite period of time to disagree. And after that, they lose their right to disagree. And so the executor can go forward and administer the estate without any worry that they're doing anything wrong or that anyone's going to challenge them. And it just sets a really clear roadmap with no potential for conflict down the road. Well, minimized potential for conflict, sorry, lawyer answer. When is a grant of probate needed? It is not needed in every case. In the province of Alberta, there's no legal requirement to obtain probate, but probate will be required when the estate owns real estate or owns financial assets held with an institution, usually to the tune of more than around $30,000 is generally what I usually assume. So that's why it's really important, if there are spouses on title to a property, it's important to have both names on title to that property, because that means it's automatically transferred and you don't have to go get probate simply in order to transfer that real estate. Again, if you are holding assets aside from the registered plan vehicles, that's a bit different. But if you've just got a savings account with $100,000 in it or something to that effect that's held solely by you, the bank is going to make you go and get a grant of probate in order to transfer that money elsewhere. However, if you've got that savings account with all that money in it and it's you and your spouse both on title to that account, the money will simply just vest in your will remain with the surviving account holder, and there's no need to get that probate. So it's important to sort of think about where everything lives when you're making your plans that way. So so when you are required to get a grant of probate, it will be because there is real estate held in the estate, or there are large financial assets held by an institution, and so that's when you'll need to go get that grant of probate. In terms of avoiding having the need to go get the grant of probate, in the province of Alberta, it's a little bit different than in some of the other provinces. There are many steps taken to avoid needing to obtain a grant of probate, and especially in BC and Ontario, because those provinces charge a fairly significant estate tax, where they tax the net value of the estate. In Alberta, we don't have that tax. In Alberta, there's simply a flat fee that you pay to the court, I think at most $525. So it doesn't matter what the value of the estate is, and it's just simply going and paying this courthouse fee, and you can apply for this grant of probate. However, the application is long and complicated, and many people would choose to use a lawyer to do that application for them. So you are going to be paying some fees, and these applications take several months to sort of get going and turn around and get completed. So there is sort of a time delay and some, albeit relatively minor, administrative fees in doing it, but it's not the same, there isn't the same preoccupation with avoiding probate in Alberta as there are in the other provinces. And as I said earlier, for the executor, there is some real legal value in getting that grant of probate, because then nobody can fight with you later about the decisions that you made. So that's sort of probate in a nutshell. So as I said, when you're looking at your plan to sort of figure out where your assets should be, and what's going to flow under your will, and whether or not you're going to try to avoid probate, it's really important to look at the other vehicles that are available, life insurance, RRSPs, because you can make sure that those financial transfers happen very quickly and without a lot of complication if you're using those sorts of things. Again, the tax advantages for life insurance policies and RRSPs should definitely be considered. And and whether or not you're going to need to probate things, so making sure that real estate has a way to flow out of your estate other than through the probate application. And again, if you're worried about insolvency, making sure that assets leave your ownership in a way that can maybe get around those creditors. So after death, so preparing your will. So what are your goals when you're preparing your will? You need to pick who's in charge. You need to set up a plan for how they go about administering your estate. You want to avoid conflict between family members. You want to ensure that your wishes are reasonably communicated and therefore able to be honored. You need to protect vulnerable family members, and perhaps you want to create a legacy by donating to charities or getting a fund in your name or those kinds of things. So you need to pick a plan, a person to do it, and then you're going to want to take care of minor children. Spouses need to be considered. Maybe there are people in your life that you want to provide for, but you need to do in a creative way, so that you make sure that assets aren't misused. Yeah, so all those sorts of things are what you would be considering when you go about doing your estate plan. Now, what is a valid will? We've all seen, the movies where you go and the lawyer writes up a big long document for you and you sign it and they stamp it and it's very official. So obviously that's a valid will. So that is a document that is created, typed up typically. You will initial each page of that. 2 witnesses will need to sign it. Those witnesses cannot be a beneficiary or the executor or a spouse thereof or your own spouse, because those people have a vested interest in creating documents that may not be in what you've actually created. So it has to be a witness outside of that. So if you are drafting wills at home independently using a kit or things like that, you'll need to make sure that the witness isn't just you and your spouse, because it will be considered that's not a valid witness. So maybe your next door neighbor is a good option, or a friend or something like that, but don't use your spouse. You can also have a handwritten will, which is called a holographic will. So if for some reason you're caught somewhere and you can't, so actually the pandemic has been very interesting for this, because when everything sort of got started, we were worried about doing witnessing because it needed to be in person. And with COVID, there's COVID-19, there's issues about being in person with people. And so early on in this process, I heard of lawyers drafting wills for people and then having them handwrite them all out. And then, and for that will to be valid, it simply needs to be signed by you in your own name. And that is a valid holographic will. So look at this pandemic, changing the legal landscape. But yes, so a holographic will is one that is written in your own handwriting and signed by you, and that is considered a legal will. It is actually quite difficult to challenge a will once it is validly signed and prepared. You have to show contrary intention or duress or undue influence, which are sort of hard bars to meet. The courts in Canada and in Alberta have decided that we have very high respect for testamentary intention, which means that people creating wills and leaving property are kind of allowed to do with it as they please, unless you can show that they weren't making those decisions in a proper way. So challenging a will is actually quite difficult, and there is no and other than leaving money to spouses and minor children or adult handicapped children, nobody else is entitled to your property. So it's kind of yours to do with as you will. So when you're preparing your will, you're going to pick out your executors and your trustees who are going to be in charge of things. You're going to pick out guardians for children under the age of 18. And the trustee for these children and the guardian may not be the same person. It will depend on the circumstances that you're going through, whether or not that's appropriate or not. You're also going to look at who of your beneficiaries need to have money placed in trust for, whether or not they can't receive it directly. Children under the age of 18 can only be gifted $10,000 or less. So if they're getting more money than that, there needs to be a trust situation set up for them to receive that money. Spousal trusts can be very useful vehicles in second marriages or in estates of large value. So something else to consider. And of course, if you're planning to leave money for the benefit of a pet, you would need to do so through a trust. And also you're going to consider how you're disposing of your assets. You want to pick out systems in order to avoid family members fighting over assets. I don't find it's often efficient to write out lengthy lists of, Susan gets the blue pot and David gets the green pot. Like those lists can sort of not be great because they may not be relevant by the time you die. They're arduous. It's hard for the executor to follow sometimes. So instead, what I often do in my wills is I set out a plan wherein if multiple people are left actual individual assets, we sort of know how people go about getting those things, so it minimizes conflict and there isn't the need for all of these lists. Also in the will, I often put in very minimal notes about funeral instructions. However, I often encourage clients to write out a memo with instructions as specific as they would like about funeral plans. So if there's music or a location or readings or people that you would like to be involved or not involved, writing this memo and just an informal memo and just sort of keeping it near your will is wonderful for your executor. Because the executors come into my office and they love it when they get this sort of informal, non-binding list of instructions, because then they know that they're serving your wishes as best they can. And so I always find that executors are really grateful for these kinds of letters. You also want to think about charitable giving. I find it sort of interesting with the clients that I see. People in their 30s and 40s are a little more nervous about charitable giving, given that usually they're like, my charity is my kids. But perhaps as people move further on in their life and they've got a bit more they've got more assets and they've moved through the world and they've got things that are important to them, and they're doing tax planning as maybe their estate has amassed to a greater amount. They often think about, you know, charitable giving that they might like to do as a lasting legacy for them and their family, and with the tax planning advantages of that. So that's something to consider. Okay, we are at the first of 3 breaks. Everybody gets to have a vote. So I think there's I think you can put your hand up in the corner. So can you have flowers delivered through your will? Raise your hand for yes. Maybe this is going to skew my results if people just aren't raising their hands at all.
Well, hands are going up.
Okay. All right.
30, well, almost 40 people have put their hands up.
Okay, excellent. Well, and the answer is yes, technically you can have flowers delivered through your will. Comedian Jack Benny stipulated that 1 red rose was to be delivered to his wife every day for the rest of her life following his death. I thought this was funny. So what a nice thought, right? Like this you know, this widow receiving a 1 red rose from her dead husband every day after his death. But then I thought about it and it was like, wouldn't it be funny if she actually hated roses? And it was just him like taking a jab at her every day for the rest of her life. And the poor delivery guy who was like, okay, it's Tuesday, off I go with my single rose delivery. So anyway, I thought it was funny. Probably just a very nice gesture, and I've seen too many wills go wrong, or the states go wrong. But anyway, entertaining nonetheless. So any of you who said yes to that, you're correct. So preparing your executor. So now that we've picked your plan, we've picked the assets, we know what we're doing, we know how we're going to structure everything. How do you get set up? So I highly, highly recommend letting your executor know that you want them to be your executor. This is going to avoid scenarios where they get appointed and then they go, oh no, I don't want to do that. You're also going to make it fairly clear within the context of your household or your family who you've picked to be the executor, so that you're not potentially creating conflict between children who thought they might have been appropriate for that role. It just allows for transparency right out of the gate. So once you've picked the executor, you let them know, you let everybody else know why you picked them. What I often encourage clients to do is to put a binder together with your will. Any banking information, passwords to computers, important information like that, any documentation where the various assets could be found, funeral instructions, emotional letters to family members that you want to leave. Put all that together in a nice binder that is easy for your executor to find, so that they can just roll things out really quickly upon your death. As I said, these funeral instructions are a really great thing to put in that binder as well, because typically on the date of someone's death, the funeral gets planned pretty quickly. So if you haven't sort of put that information in an easily accessible spot for your executor, I've also seen it that they plan the funeral, they've done the whole thing, and then 3 months later they find, you know, a letter saying, oh, I've already prepaid for a funeral, you know, at this place, and it's like, oh, well, oops. So making sure that you're putting plans together so the executor has a nice, easy picture right out of the gate is a really smart thing to have, and is nice for them so that they're not starting from scratch. So I won't go into this for too much, but so so back to the married with children guy. So if you are preparing your will, there will be some special considerations you'll want to consider upon a second marriage, or certainly even a separation or a divorce. You're going to need to understand that you may still have ongoing obligations to your first spouse if there are divorce or separation contracts providing support. And you're going to want to make sure that the will that you've got is not in contradiction with those agreements, so that you're not creating conflict there. If upon a second marriage there were children from a prior relationship, you're going to want to use estate planning to make sure that there isn't conflict between those children and that new spouse, because nobody wants to start that fight. So there are great tools that you can use to sort of protect your new spouse, but balance interests with prior children through, as I said, through spousal trusts and insurance policies, and making sure that you're coordinating any new marriage contracts or prenups or separation agreements and divorce agreements. Again, special consideration will need to be taken with your estate if there are family-run businesses that you are passing on to some members of your family and not to others. You are fully entitled to disinherit or to provide different inheritances for different children. There's nothing saying you have to be equal, but I sure find it avoids a lot of conflict when things end up being kind of equal, or steps are taken to sort of mitigate the inefficiencies given to different family members. So if there is a family-run business that you are handing down to one child or not, which is very common in farming families. In my own personal circumstance, my father runs a legal practice, and I am the eldest of 4 daughters. 3 of us have law degrees, 1 doesn't. She's a scientist. We made her move to England, so it's okay. But as the remaining 3 of us, you know, will we work for, I happen to now work with my father, but my other 2 sisters work at firms. But you know, what benefit may I be getting by maybe inheriting this business that the others wouldn't be getting, or the daughter who can't practice law, so she's not getting any interest in it. So how do you go about structuring it so things are made a little bit equal? And a great way to do this is through using business insurance policies to do payouts to various family members where they may not be getting other interests. If there's real estate, considering who goes on title to those things. So, in order to avoid conflict as between family members, I find when you are dealing with a family-run business like this, there's really creative ways you can use to avoid that conflict after your death. Loans or gifts to children. So, again, avoiding conflict after your death, wherein maybe you have 3 children. You gave one child, you know, a down payment for a house. Another child just never necessitated that or didn't ever need something like that, so they didn't get it. I have seen more people walk into my office and say, "Yeah, but my sister got $60,000 15 years ago, and I never got it, so that should come out of her inheritance." And we all go, "Oh, who knows?" Because it's not specified. So when you are doing estate planning like this, it's important to sort of run through your head. And if there are groups of people in your life that should be treated somewhat equally, that you've treated in one way and others in a not, it's really important to write out your intentions as to whether or not that unequal treatment should be considered as part of their inheritance, or if it's just to be written off as a gift, a one-time gift. So much conflict can be saved by just spelling out what your intentions were, and it's not hard to do. I just often do it in a one-liner in the will, and then nobody can fight about it. So just something to think about, and a very easy solution for what can end up being big sources of conflict. When do you need to update your will? So typically, if your will is done in a good way, my goal is that, bearing any major changes in your life, you should never have to update your will. Your will consider who your executors are through different generations as you age. It will set up trusts for children and then subsequently grandchildren if everybody grows up and gets big, when everybody grows up and gets big. And it'll sort of anticipate major steps in your life. That being said, if there are divorces or changes in the needs of various people in your life, or charitable legacies that you'd like to create later on, those are times when you should be looking at updating your will. It's also a great idea, so for people that are drafting their wills in their 40s and 50s perhaps, it's a really good idea to go back and look at who the executors you picked out at that time are, because probably they will be siblings or friends that are in the same age group as you. But if you're then looking at that will in your 70s or your 80s, it may no longer be appropriate for your sibling to be your executor. And maybe you then want to look at a child or a niece or a nephew. So executors are a really good one I ask people to go and look at. And again, perhaps you put in very specific gifts to people with things that you owned 20 years ago that maybe you don't even own anymore. So it's a good idea to just go and look through the dispositions that you are giving and the people that you've appointed to be in charge, because they may no longer be appropriate. So I recommend that every 5 to 10 years, just have a look at your documents and see if everything is still relevant and makes sense. If they're minor changes, you can very easily and cheaply fix them with a codicil, which is just a short document you add to the end of your will. If there are more major changes, then you probably would need to redo the will. But many, many, many things can be changed in a simple codicil. Okay, the next vote. Can you leave it all to the dog? I know I've probably talked about this more than I needed to with Stella. But okay, hands up if you think you can leave it all to the dog.
Ooh, hands are going up quickly this time.
That's why I don't have any pets.
Well, we've got about 60 people almost 60 people who had raised their hands.
Okay, well, and the answer is technically yes. In 2007, one lucky dog inherited $12 million when its owner, businesswoman Leona Helmsley, died. She left her fortune to her Maltese named Trouble. So what would have happened in this case is that Ms. Helmsley would have created a trust with a trustee and put the assets in the trust to be there to care for the dog. So technically the answer is yes. So what happens if someone dies without a will? The law sort of kicks in and tells us what happens if somebody dies without a will. There are very specific regulations that say if you die without a will, all your assets go to your spouse. If there is no spouse, or common law partner, then to your children. No spouse, no children, then it goes to your parents, I think, and then after that to your siblings. So but if you get too far away, then it all goes to the government. So make sure you're figuring out who you'd like it to go to. These regulations also stipulate who has first priority to apply to be your executor. And the sort of so beneficiary designation, picking out beneficiaries isn't all that complicated under this scenario because it's sort of prescribed as to who gets what. However, I see conflict in this scenario oftentimes as to who should be the executor. Because in a will, you're just spelling it out and everybody has to kind of play along. But if you haven't sort of made that decision and you've got a couple of kids and no spouse, or the spouse doesn't want to do it, all of a sudden you've got conflict as between the kids as to who should be the executor. There's mistrust and back and forth and back and forth. So simply just having the will that says this is who should be in charge cuts out a lot of conflict right off the go so that nobody's fighting about just simply that position of power. Alberta, incidentally, is the only province in the country that stipulates that if there is a spouse and children from a prior relationship, the children from the prior relationship do actually get to receive estate assets. So the new spouse would get the first $150,000, and then they have to split the rest with the children from the previous marriage. So it's interesting. We're the only province that felt that this was important. But anyway, interesting to me. Okay, on we go. Now, if someone dies that you are dependent upon, and they die without a will, the law sort of stipulates that support has to be provided for those people. So spouses and minor children and adult handicapped children have recourse against an estate if they're not taken care of adequately, where they can go and fight for more support. So if you die and you don't have a will, and let's say you have 3 children and you have whatever assets you have, and under the normal circumstances, those assets would be split between your 3 children, but let's say one of those children is a minor or an adult dealing with significant handicaps, that more vulnerable child can actually go to the court and say, I think I should get more than my 2 siblings because I need it. And so there is recourse to do that. As we sort of got into earlier, there were some changes to the existing laws a few years ago that talked about marriage and separation. I sort of got into that already, and some of the intestate. So I'm not going to go really further into this, but just so you know that those are there. Okay, so before you die, so those are the questions on our wills topic today. Now, before you die, it is possible that you could be in a scenario wherein you're incapable of making decisions for yourself, and you may become vulnerable in that sense. For these types of documents, we separate legal and contractual issues from healthcare making decisions. So if something were to happen, like a car accident, and you go into a coma, or you suffer from dementia, or things are just sort of hard for you from a mobility standpoint, or you spend 6 months out of the year in a different country once COVID is over, it's a great idea to have a power of attorney set up in place so that there's a person designated to deal with financial and legal issues for you, so they can enter into contracts with phone companies or utility companies or lawyers, or they can handle litigation for you. They can deal with the bank on your behalf. So for example, if you spend 6 months of the year in Florida or California, you can have somebody back home sort of managing things for you from a legal perspective. It's very handy. The other thing about this is that if you don't have somebody like this appointed, and you do become incapable by way of some sort of medical issue, with privacy laws today, it can be a really sticky situation, because if you've entered into a utility contract or a phone contract, those companies will not speak to anybody else in your family. They will only deal with you. So if you don't have somebody legally designated to deal with them, you can run into some troublesome issues here. And if you are found to be incapable and can't deal with things in this way anymore, your family may be forced to go before the court and get a guardianship or trustee appointment, which is a lengthy process. It's expensive. All these background checks have to be taken on the trustee and the guardian. They have reporting obligations from here on out, so that costs thousands of dollars. It takes a lot of time. It's very arduous for your trustee or your guardian. So if you can go and have one of these powers of attorney documents drawn up for a couple $100, just putting somebody in charge, you avoid all of this stress and conflict for your family. So on the other side of that, so aside from your financial and legal issues, there's also personal directives, which are the healthcare issues. So in this case, you're appointing an agent to take care of medical decisions for you. They can pick medication that's appropriate. They can make end-of-life decisions for you, organ donation, those sorts of things. They're allowed to give and receive information from doctors. And again, with the privacy laws these days, doctors are more and more wary about who they should be providing medical information to and who they can take instructions from. So it's really important to sort of have these documents in place, while you're in a healthy state of mind. And you also want, and also as between family members, you want to make sure that you're empowering the people that you want to take care of you, so that you're not creating conflict within your family about what should happen. Now, this is different from a DNR. So a lot of people will have filled out their do not resuscitate form, which is a green sleeve that I think they advise you to keep on your fridge. That is different. That form only advises emergency personnel if they arrive on the scene and something is happening in an emergency scenario. That is not applicable to sort of like an extended term where you're suffering from dementia, which is what a personal health care directive would stipulate. So again, really important to have these documents in place while you are of sound mind and capable, because if you're not, and you get into a situation where you are no longer capable and important decisions have to be made, again, your family may be forced to go and get a guardianship appointment through the court. So again, a couple $100, quick conversation with a lawyer, or you can do it online. This makes a big difference when your family members are trying to take care of you. Okay, So I sort of talked about this, but if you don't have those powers of attorney or healthcare directives in place, it can create conflict in your family as between family members trying to decide who should be in charge. And if they're trying to deal with other entities, those entities may not even be prepared to deal with your family without sort of an appointment. So then you're forced to go through this time delay, expense, those kinds of things. So we have one more skill testing question. Can you cause a baby boom through your will? Hands up if you think yes. I'm not very original, I guess, in terms of the voting options.
Well,
Okay.
people don't seem to be as sure about this one. Only 18 hands up right now.
Uh-oh. All right, well, the answer is sort of. Charles Miller, a Toronto lawyer and businessman, left a sizable asset up for grabs to pretty much any local woman. So he sort of said, okay, ladies, you got 10 years. For any woman who has the most children in the next 10 years, you get this asset. And so I think the winner had 9 children. And so she got whatever this was. So it was called the Stork Derby. Anyway. And but can you think of the woman who has 8 children and is like, oh, darn, it was 1 child too short. You still have 8 children. I have 2 and it's a lot. So I don't know why anybody would enter this race, but technically probably a lot of extra children were generated as a result of this prize, maybe. Anyway, I thought it was entertaining.
Perfect. So I want to thank you, Colleen, for your time and your expertise. I want to thank our audience for tuning in. Hopefully they learned a lot. Your contact information is up on the screen right now. So if people have some more specific questions or wanted to reach out to you about their will, perhaps they could give you a call or send you a quick email. I will remind everybody that if you've joined late or want to go back on something that you missed, we should have these recordings up on our website, ecfoundation.org. We really appreciate you tuning in. Thank you for being a part of this, and do let us know if you have any questions. Thank you very much.